You have testified, and stop me if I get this wrong, that judges should stay in their lane. And I think it's fair to say that one of your definitions of staying in your lane is that judges don't make policy. Am I right so far?
Yes, that is correct.
Welcome back to Hot News Today. The Senate Judiciary Committee is back in action, and Senator Kennedy wasted no time coming out swinging at President Biden's Supreme Court nominee.
Senator?
Then how do you explain, or help me understand, the following? We have a judicially created doctrine with no textual basis either in the Constitution or a statute called substantive due process. And through substantive due process, our federal courts, let's just narrow it down, the United States Supreme Court has given itself the authority to read into the Constitution unenumerated, unmentioned rights. Not read the Constitution and say, well, there it is, freedom of speech. But these are unmentioned, unenumerated. Isn't that making policy?
Senator, the Supreme Court interprets provisions of the Constitution, and there are provisions of the Constitution that require interpretation because they don't just on the text in every circumstance answer the question before the court. So due process, what does that mean? And the Supreme Court has, the words due process do appear in the text of the Constitution. And the question is, what is covered by that provision? The Supreme Court,
At the heart of today's fireworks, the age-old battle between judicial power and judicial restraint. Are judges supposed to call balls and strikes, or are they rewriting the rule book? Kennedy kicked things off by grilling the nominee on staying in their lane. He hammered down on the doctrine of substantive due process. Basically rights the court finds in the shadows of the Constitution. Kennedy asked, point blank, isn't that just judges making policy instead of interpreting law? The nominee was careful, saying judges interpret, not legislate. But Kennedy wasn't buying it, calling out what he sees as policymaking from the bench.
I was just going to say, but when they do it, aren't they making policy?
Well, Senator, the role of the judiciary is to interpret the law. To the extent that somebody argues to the court that there's been a violation of the due process clause of the Constitution, it is within the role of the court to determine what that means, whether the person is correct that what happened with respect to their case violated the due process clause. And so there's an interpretive function that is a part of the judicial function.
Here, let me see if I can put a finer point on this. It's not the right so much. It's how the right is created. That's why I asked you yesterday whether you think that these unenumerated, unmentioned rights ought to be decided by the people through their elected representatives versus the federal judiciary. Let's take two rights that I talked about yesterday, the right to assisted suicide, the right of a transgender woman to participate in women's sports. I can see how, I'm not predicting that it will, but I could see how the court, either through the due process clause or the Ninth Amendment, could find those rights in the Constitution. As we talked about yesterday, the Supreme Court looks to me like they've adopted the policy of there is no test for a fundamental right. There are several tests. And in Obergefell, Justice Kennedy cited with approval Justice Harlan's dissent in Poe v. Oldham, which says there's no test. We go case by case.
Next, Kennedy dug into who really decides America's most explosive issues. Rights like assisted suicide or transgender athletes in sports, should those be settled by the people or by 5 justices in black robes? The nominee admitted it's a tough balance. Democracy lets us vote, but the Constitution protects some rights even from majority rule.
And but I know there are tests, like I'll get the language here somewhere, I've got it, I don't want to look it up, but implicit in the concept of ordered liberty, and you've talked about that. Here's a new one that Justice Kennedy talked about in Obergefell. He said, inherent in the concept of individual autonomy. Well, I can see how if the court with 5 votes wanted to say, even though the right to assisted suicide or the right of a transgender woman to participate in women's sports. I can see how somebody, you're smart, you could write an opinion and say that's inherent in the concept of individual autonomy. And maybe, again, it's not the right. It's who's supposed to decide. And that's where the judicial restraint comes in. I mean, don't you think that the values of ordinary Americans and their ability to decide these issues are just as good as those of 5 members of the Supreme Court?
Thank you, Senator. There are policy determinations that are made by vote, and absolutely in the democratic process, people get to decide things. The question and the difficulty is when you have a constitutional scheme of government and you have a constitution that certain rights, and it does so in a circumstance in which those rights, whatever they are, enumerated or not, are might be things that the people have disagreed with. That's the tension. That although we have democracy as we do, and people vote and should absolutely, we also have a constitution that protects certain rights against the sort of majority will about those things.
Kennedy pushed back. If these rights aren't in the Constitution, how honest is it to say they're protected at all? Then things got even spicier. Kennedy warned about the managerial elite, the powerful few making decisions for everyone else. He pointed to a case where Congress gave sweeping authority to DHS, but the nominee blocked them, citing the Administrative Procedure Act. The D.C. Circuit reversed that call, highlighting the ongoing struggle over who really holds the reins.
Thank you, Senator, for allowing me to address that decision in that case. The statute at issue gave discretion to DHS to determine the amount of time that a person needed to have been in the country between 0 and 24 months in order to be subject to expedited removal, as opposed to the normal removal process in the immigration system. The statute said that DHS had sole discretion, meaning meaning no other agency was to have the authority to make that determination. And the statute said that DHS's determination in that regard was unreviewable, meaning it was final. Once, this is how I'm interpreting, meaning that once the decision was made, it was over. Nobody else gets to review. The court doesn't get to say, no, you're wrong if you pick 12 months, for example, or 16 months or 24 months, as they did in this case. The statute did not speak to whether Congress intended, with that grant of very broad discretion, to exclude another statute that Congress has passed that directs agencies, when Congress gives them discretion, the other statute, the APA, directs agencies as to how they go about making decisions that Congress has given them the authority to make.
Finally, Kennedy zeroed in on sentencing laws for crack versus powdered cocaine. Was that a judicial issue or Congress's call? The nominee stuck to their guns. Courts apply the law, Congress makes the rules, even if they don't always make sense. So here's the real question. Should unelected judges expand rights, or should that power stay with the people and Congress? Kennedy says too much judicial power breeds distrust. The nominee, they're sticking with the Constitution. This fight's not over, and neither is our coverage. Hit like, comment your take, and subscribe to Hot News Today for more on this Supreme Court showdown.